I was listening to the Bulwark podcast yesterday. I think it's just called George Conway Explains It All. And George Conway, very gifted, very smart attorney, former husband of Kellyanne Conway. Um, he and Bulwark publisher Sarah Longwell do a weekly podcast where George just kind of explains a lot of stuff. And a lot of it gets pretty deep in the weeds, but there's some good explanations and things like that. And they were having this conversation about how to reform various things. Reforming money in politics and reforming how the House of Representatives works and reforming the power of the office of the president. And eventually they came around to reforming the Supreme Court, which is obviously something that is in deep, deep need of reform. And George had some really good ideas in this regard, a couple of which that I hadn't thought of before. But one of like two of the favorite things that I hear from people on the left when they start talking about the Supreme Court is they're like, you got to pack the court and we need term limits. Packing the court is not going to happen. No president really has the power to do that. It's a separation of powers issue. It's the judicial branch versus the executive branch. The office of the president doesn't have any power over the judicial branch. And then, and everybody always comes back around to term limits. We need term limits. Well, you can't do term limits unless you reform the Constitution, because in the Constitution it says federal judges, Article 3 judges, are appointed for life. And so you can't override the Constitution with legislation from the legislative branch. You can't override the Constitution with an executive order from the president from the executive branch. And so term limits is not a thing. That's never going to happen. But then George mentioned a couple of other things that I thought was really interesting, which I'd never thought of because they generally apply to the appellate court level, the circuit courts. It's very common for circuit court judges, judges who have been appointed to the federal appellate court. Once they get older, they've been doing it for 30 or 40 years, to take what's called senior status. It's like they still get paid. They're still a full Article 3 judge, but they take on senior status, and which just means a much reduced caseload. And, they're generally picking up the cases that the other judges just don't have time for. But they're available for other things, other functions within that appellate court as well. And he was like, you can't do term limits because that's in the Constitution, that they're appointed for life. But he's like, you could put an age limit that once they hit a certain age, like 72 years old, they're still on the court for the rest of their life, but you can compel them into senior status and kind of backbench them. And so a president gets to nominate a new one. So you are expanding the court, but you've just got these justices that are on senior status because of their age, and it reduces their workload. They're not on the panel of 9 that hears cases, but they're available for other things. They can fill in when one justice is going to be out for oral argument, that kind of thing. And I thought that was a pretty interesting discussion. I mean, it's totally commonplace at the appellate court level, and within the Constitution, the only difference between district court or circuit court judges, the appellate judges, and the members of the Supreme Court is which court they sit on. They're still Article 3 judges. They're still appointed for life. If you want to remove them, you still have to impeach them. But I appreciated his thoughtfulness and his creativity in expanding that common practice on the circuit appellate courts to the Supreme Court. I think that's something that could gain some traction the next time the Democrats control the House and the Senate and the White House. So if that ever happens again in my lifetime, LOL, I'm gonna beat that drum. I'm gonna beat that drum.